Hey everyone, welcome back to the channel Law in Motion, where we explore some of the most impactful legal cases in history. Today, we are diving into the case that shaped the way the legal system deals with insanity as a defense, R versus McNaughton, a case from 1843 that established the legal standard criminal insanity. The story starts in 19th century England. Daniel McNaughton was a Scottish woodturner who had become convinced that he was being persecuted by the British government. His paranoia grew to the point where he believed that the Prime Minister, Sir Robert Peel, was plotting against him. On January 20, 1843, McNaughton took drastic action. Believing he was acting in self-defense, he shot and killed Edward Drummond, the private secretary to Sir Robert Peel, mistaking him for the Prime Minister. McNaughton was arrested and charged with murder. But here's where things took a legal turn that would forever change criminal law. His defense team argued that he was not guilty because he was insane at the time of the killing. They claimed he couldn't understand the nature of his actions due to his mental illness. The trial attracted huge public attention, and after hearing from multiple medical experts who testified about McNaughton delusions, the jury acquitted him on the grounds of insanity. This verdict, however, sparked widespread outrage. Many people, including Queen Victoria herself, were shocked that someone who had committed such a serious crime could avoid punishment because of their mental state. But what really shook the legal system was the aftermath. The public outcry led to a formal inquiry by the House of Lords, and this inquiry resulted in what we now call the McNaughten Rules guidelines for determining criminal insanity. The McNaughten Rules set the standard for the insanity defense, a legal principle that still exists in many countries today. The key question they introduced was this: does the defendant have the ability to distinguish right from wrong? Under the McNaughten Rules, a defendant can be found not guilty by reason of insanity if, at the time of the crime, they were suffering from a defect of reason, caused by a disease of the mind, to such an extent that they didn't understand the nature of their actions or couldn't tell that what they were doing was wrong. The McNaughten Rules became the foundation for the insanity defense in many legal systems around the world, and they have been used in some of the most high-profile criminal cases since then. However, these rules also raised many questions. How do you measure someone's ability to know right from wrong, and who decides what constitutes a disease of the mind? Section 84 of the Indian Penal Code and Section 22 of Bharatiya Nyaya Sanhita talks about act of a person of unsound mind. It provides the legal defense of insanity. It states that an act is not an offense if it is committed by a person who, due to unsoundness of mind, was incapable of understanding the nature of the act or that it was wrong or contrary to law at the time of committing it. Essentially, if a person lacks the mental capacity to distinguish between right and wrong due to insanity, they are exempt from criminal liability under this section. The burden of proving insanity rests on the accused. So, what do you think? Should the insanity defense be more flexible to account for different mental conditions, or should the McNaughten Rules be enough? Let us know your thoughts in the comments. That wraps up our look at the R versus McNaughton case. If you found this video helpful, make sure to give it a thumbs up, subscribe to our channel, and hit the notification bell so you never miss an update. Thanks for watching, and we'll see you in the next video.